Hello everyone, and welcome to the third of our video tutorials on the topic of the judiciary. In today's video, we're going to be looking at the independence of the judiciary. Independence of the judiciary is something we touched on in our last video tutorial when I mentioned that judges have security of tenure, meaning that it's difficult to sack them. And I mentioned then that that's important so that they feel independent. So we're going to look today in a bit more detail about what independence of the judiciary is, why it's important, and to what extent we have it. So it's vitally important in a democracy that individual judges and the judiciary as a whole are impartial and they're independent of all external pressures and of each other, so that those who appear before them and the wider public can have confidence that their cases will be decided fairly and in accordance with the law. And when carrying out their judicial function, judges must be free from any improper pressure. So let's have a look then at what improper pressure judges could be subjected to. Such influence could come from any number of sources. It could arise from improper pressure by the executive or by the legislature, by individual litigants themselves, particular pressure groups, the media, self-interest of the judge themselves, other judges, and in particular perhaps more senior judges. So there's lots of places where pressures might come from and might be placed on a judge to make a decision in a particular way. Judicial independence is so important because it's vital that each judge is able to decide cases solely on the evidence presented in court by the parties and in accordance with the law. Only relevant facts and law should form the basis of a judge's decision. It shouldn't be made, obviously, on the basis of a bribe or pressure from somewhere else. As well as, in fact, being independent, it is of vital importance that judges are seen to be both independent and impartial. Justice must not only be done, it must be seen to be done. And it was for this reason that the House of Lords, in the Pinochet case in 1999, held that a decision it had given had to be set aside and the appeal before it heard again by a panel of different law lords. And the reason this was set aside was because it had come to light after the original decision that one of the law lords might have given an appearance that he was not independent and impartial because of a connection with a campaigning organisation which was involved in the case. And in those circumstances, and even though there was no suggestion that the law lord was not in fact independent or impartial, the decision couldn't stand. Justice demanded that the appeal be heard again before a new panel of law lords who had and gave the appearance to reasonable, well-informed observers that they were independent and impartial. And in the Pinochet case, Lord Hoffman said that judges should be independent from the executive, interest groups, and litigants, to have an independent pay review, to have no other paid appointment or profession or business, and not to sit on a case in which they have or appear to have a personal interest or bias in. Have a look then at some of the ways in which our judges are independent. We've already mentioned security of tenure in a previous video, that it's very difficult to sack a judge. And the reason for that is that we want judges to be able to make decisions that they think are correct, not decisions that they think are going to be popular and prevent them from being sacked. The second one here, immunity from suit, this refers to the fact that judges are given immunity from prosecution for any acts they carry out in performance of their judicial function. And they also benefit from immunity from being sued for defamation for the things they say about parties or witnesses in the course of hearing cases. Now, lots of people are quite critical of that and say that in this way judges are somehow, quote, above the law. However, it's not right to say that judges are above the law. Judges are subject to the law in the same way as any other citizen. We know already that the Lord Chief Justice or the Lord Chancellor may refer a judge to the Judicial Complaints Investigations Office in order to look at a judge's behaviour, but the general immunity from suit is required in order to secure judicial independence. It's also important, of course, that our judges are separate from the executive. And Section 3 of the Constitutional Reform Act 2005 states that the government must uphold the independence of the judiciary. It would be clearly inappropriate for a judge in charge of a criminal trial, say, against an individual citizen, to be influenced by the state. It'd be unacceptable for the judge to come under pressure to admit or not admit certain evidence, or how to direct the jury, or to pass a particular sentence based on pressure from the state. Decisions must be made on the basis of the facts of the case and the law alone. It's also important, of course, that judges are separate from the legislature to comply with separation of powers. And we know that judges are generally not involved in the lawmaking functions of Parliament. The creation of the Supreme Court in 2009, thanks to the CRA 2005, separated the judiciary from the legislature. And we've seen from the case of Pinochet that judges must be totally independent from the case, and judges should not try any case where they've got any interest in the issue involved. And if we remind ourselves about the case of R on the application of Miller and the Prime Minister, this is a lovely example of how important judicial independence is. In this case, if you remember, the Supreme Court justices made a decision against the Prime Minister without fear of losing their jobs. So it's very important that they felt able to make a decision based on what they thought was right according to the law, not about fear for their own jobs. In my Judiciary PowerPoint, I have put a link in so you can have a look at the judgment of the Supreme Court against the Prime Minister, because it's a really interesting one to have a look at and gives you a nice insight into how the Supreme Court works and how judges deliver verdicts. And you'll also probably recall that following that decision in Miller and the Prime Minister, the judges were criticised for their decision in some of these papers, as you can see here. It was an inaccurate representation of the case, but it shows that if judges were feeling pressure from the media, they maybe wouldn't have made the decision that they did. I'm thankful that they made the decision based on the law, not out of concern that the next day they might be portrayed like this. We've been looking at independence of the judiciary. We've touched on the concept of separation of powers again, which we looked at in the topic of parliamentary lawmaking. So an independent judiciary links to separation of powers because we want our judiciary to be sufficiently separate from these two arms of state so that it can make decisions that it thinks is right. And separation of powers is linked to the concept of the rule of law, which, among other things, aims to ensure that the judiciary can constrain the executive to working within the boundaries of its lawful authority through judicial review. And it's also linked to the principle of judicial independence, as I've just mentioned. And this is where, yet again, I will refer you back to Miller and the Prime Minister, because this case illustrates the importance of an independent judiciary, but it also illustrates the importance of separation of powers, because the Supreme Court was acting as a check on the executive. So it ensured that the Prime Minister hadn't become too powerful. And this was an example of the court using judicial review. And they found that Boris Johnson was ultra vires and he had gone beyond his powers. A really useful activity to do at this point, to end our tutorial today, would be to think about to what extent we do actually have separation of powers. Because we know that Montesquieu said that all states should have separation of powers, but to what extent do we have it? And you could make a chart like this with, yes, we have separation of powers with all the arguments that support that, and another column perhaps no, arguments that we don't fully have separation of powers. And that's the end of our tutorial for today.